Hello, this is a video on the role of the lawyer in very broad terms that I want to do today, which is the 3rd of May 2018 for a mentorship group and anybody else watching in that group. The group has grown to 120 people. If you have friends who are lawyers, paralegals who would like to watch our videos, please ask them to join the group. You can make your comments below. But today's topic is the role of the lawyer in the broadest sense, which is what does he do on a daily basis. But I also want to include the paralegals in this arrangement because they play the same role in the small claims court and other places such as enforcement of bylaws, in the landlord-tenant issues where they have jurisdiction. So this discussion today applies to both the lawyers and paralegals in what do they do on a daily basis. So from my point of view, we are engaged in the process of problem solving from the two perspectives and sitting in the middle to try to achieve the resolution between what the client wants and how far can we get the opposing party to accommodate to our position. So firstly, let's take a position of the client. He comes to you either as a plaintiff or a defendant, and you have to deal with him in what I call the private enterprise adversarial system, which means that we bill him and he has to be happy with what you do, how do you present yourself, what your reputation is like, and how much do you charge an hour or a block fee. So first of all, for a fee, you are trying to solve his legal problem. It's very important that we keep in mind that we are in a problem-solving arena where we need to address the question that the client raised in the defense or claim and formulate this in the legal format procedurally and substantively. And once you have done it, you're dealing with the opposing side, in which you are telling the other side by issuing the claim or filing a defense to say that we disagree and we have a different point of view. In conducting this relationship with the opposing counsel, which can be a paralegal or a lawyer, we have to also deal with him from his point of view. So when we do this thing, we are doing this in adversarial format, which is a little bit, if I can call it that, hostile as a format, because the very nature of the way we deal with the claim or defense in the adversarial system is to formulate our views and support one side. And that one side is already opposing and fighting with the opposite side. And therefore, when we deal with the opposing counsel or a paralegal, we have to deal with him from a certain degree of adversity, as you might call it, or hostility, if you want to call it, but we still have to manage the relationship. And I think in the Ontario profession, the rules of civility were introduced a few years ago for that reason, because some lawyers or paralegals get out of hand, if you like, and then assert their client's position in a rather strong manner, uncivil manner, and therefore our fundamental idea is that we have to conduct the relationship in a civil manner. When you do civil relationship, for my approach is to you become technical and show to the other side that we do want to solve the problem. And you gain the negotiating position not by expressing your hostility, but rather by creating a relationship in which you accommodate the other person procedurally if you can, or in understanding and showing understanding of the opposite side, and then showing your side with technical arguments that will to some degree convince the opposite side that you have a good point of view. In conducting that relationship with the opposing counsel is also a relationship problem, because you will see over time that if you deal with the opposing side in a hostile manner, they will react back also in a hostile manner. So you have to set the ground rules right up front when you're dealing with the opposing side, that you want to deal with the other side in a reasonable manner. You'll write it down, and if the lawyer is too angry or a paralegal is too angry with you, then you have to calm him down by simply saying that, can we deal with it another time? Sometimes you see the conversation going interrupted. In those cases where you identify the other party as a person that not able to control themselves properly and over-enthusiastic, as I would put it, in trying to solve their client's problem, then it is better to do it all in writing. And when you write the letter, I would not underestimate the value of properly written letter, which should be polite but technical and convincing the other side that your position is correct, and that if you go to court, you have sufficient law on your side along with the facts that you ought to understand, and therefore if you advance that position, even the cost position at the hearing will be on your side. So hope this was helpful, and please join the group if you like, and if you like the video, please share it with other people that you know. And our membership group includes lawyers, paralegals, and even the public interested in solution of the legal problems and get to know how the legal system works. Thank you for watching.